You may be wondering, what is procurement integrity and why should I care? The government's buying process is known as an acquisition. Congress enacted the Procurement Integrity Act and other laws to govern and preserve the integrity of the acquisition process for buying goods or services using appropriated funds while ensuring fair treatment of offerors. Penalties for Procurement Integrity Act violations. There are consequences for violating procurement integrity that range from administrative actions like canceling the procurement, rescinding an awarded contract, initiating suspensions and debarment for contractors, or adverse personnel action for federal employees, to civil penalties, which include fines, and up to criminal penalties for disclosing or exchanging information for something of value to allow anyone to obtain a competitive advantage. Safeguarding procurement information. If you're watching this video, all this applies to you. Your next question should be, how do I safeguard procurement information so I'm not in violation? First of all, you need to be aware that there are two types of procurement information: proposal or quote information and source selection information. You need to protect both proposal or quote and source selection information. Let's define these types of information so we're all on the same page. When industry partners bid on a government solicitation, they submit information directly to the government as part of a proposal or quote package. This is an offer in response to the solicitation. This offer is not made public and may include technical solutions, staffing plans, subcontractor information, and proprietary information. Think manufacturing processes, operations, or techniques, cost or pricing data such as indirect costs and direct labor rates, and any information marked by the contractor as contractor proposal or quote information in accordance with law and regulation. Source selection is defined as information and documentation prepared by the government for an evaluation of a proposal or quote. Source selection is not made public and includes technical evaluation plans, technical evaluation of proposals or quotes, individual and consensus documentation. Examples include the acquisition plan, performance work statement or PWS before release, task order request or TOR, or request for quote or RFQ before release, proposed cost or price information and government evaluation of price. Examples include the independent government cost estimate, and other information marked as source selection based on a determination that its disclosure would jeopardize the procurement. Examples include work products of the Technical Evaluation Board, Contract Review Panel, or Pricing Team. Prohibition on disclosing procurement information. The Procurement Integrity Act prohibits the knowing disclosure of procurement information. This law applies to federal employees and contractors who have or had access to contractor proposal or quote information or source selection information by virtue of their office, employment, or relationship, present or former officials or employees of the government, a person that is acting or has acted for or on behalf of the government, or a person who is advising or has advised the government regarding the procurement. Prohibition on obtaining procurement information. The Procurement Integrity Act also prohibits knowingly obtaining procurement information. This law applies to anyone, both federal employees and contractor personnel. Conflicts of interest. In addition to procurement integrity, there are many types of conflicts of interest, or COI, which need to be identified and disclosed, such as financial COI, personal COI, and organizational COI. Financial COI. According to U.S. law, you are prohibited as an officer or employee of the executive branch from participating in any capacity in a procurement where your spouse, your child, or your prospective employer have a financial interest, as this would qualify as a financial COI. You have a financial COI if you have financial interest in an offeror or a covered relationship. More on covered relationship next. Personal COI. You have a personal COI when you are in a covered relationship, which is defined as having direct stocks in companies that are bidding, relatives may be employed at companies that are bidding, spouse, child or children, or business partners have a financial interest in companies that are bidding, or relationship with someone seeking employment or business, contractual, or other financial relationship. Questions you should ask to determine if you have a covered relationship include: are any of the offeror companies a present or prospective employer of a spouse, parent, or child? Within the past year, have you been employed or are currently employed, or in another capacity, by any of the companies? Organizational COI. As a result of other activities or relationships with other people or organizations, organizational conflict of interest or OCI may exist if a person or organization is unable to render impartial assistance or advice to the government. A person or organization's objectivity in performing the contract work might otherwise be impaired. A person or organization might possess an unfair competitive advantage. Questions you should ask to determine if you have an OCI include: does the organization have any of the potential offerers under contract with access to the work? Is protected information being used in this acquisition? Are the potential offerers firewalled? Disclose COIs. To be compliant requires full and prompt disclosures and may require divestment or recusal from the procurement. If you have any actual or potential COI, you should immediately disclose to the FedSim contracting officer or CO so they can deal with the issues raised, make a decision regarding the disclosure, have an opportunity to mitigate if appropriate, and document the contract file. Your lack of disclosure can result in delay or potential cancellation of the acquisition, as it would raise questions regarding the overall integrity of the process, and may result in civil or criminal penalties. NDAs. An NDA must be signed by all members of the TEB as well as client technical advisors and observers after the TEB training. The NDA is signed to acknowledge that no actual or potential COI exists that may diminish their capacity to impartially review proposals submitted or result in a biased opinion or unfair advantage. Recusal due to Simplified Acquisition Threshold, or SAT. For federal employees who are participating personally and substantially in a competitive procurement valued in excess of the Simplified Acquisition Threshold, you must pay attention and follow protocol in these two scenarios. Number 1. If you contact an offerer in that procurement regarding possible non-federal employment, you must promptly report the contact in writing to your supervisor and agency ethics official. GSA employees report to the GSA Office of General Counsel or OGC Ethics Counsel. Federal employees must report to their own legal and ethics counsel. Number 2. If you are contacted by an offerer in that procurement regarding possible non-federal employment, you must reject the possibility of non-federal employment or recuse yourself in writing from further involvement in that procurement until authorized to resume participation. If recusing, promptly inform the FedSim CO. Prohibition on accepting compensation from a contractor post-employment. If you served as the procuring CO, the source selection authority, or a member of a source selection technical evaluation board at the time of selection of the contractor or the award of the contract, you may not accept compensation from a contractor as an employee, officer, director, or consultant for a period of 1 year after the date of service for contracts over $10 million. If you served as the program manager, deputy program manager for a contract in excess of $10 million, you also may not accept compensation from a contractor as an employee, officer, director, or consultant for a period of 1 year after the date of service. Here are relevant examples where you may not accept compensation from a contractor if you award a contract, subcontract, modification of a contract or subcontract, or a task order or delivery order over $10 million, establish overhead or other rates for a contractor on a contract or contracts valued in excess of $10 million, approve a contract payment or payments over $10 million, pay or settle a claim in excess of $10 million with that contractor, served as a voting member on a technical evaluation board for a contract or contracts valued in excess of $10 million. Post-employment prohibition on representation. Post-employment prohibition does not apply to divisions or affiliates of a contractor that do not produce the same or similar products or services as the entity of the contractor, 48 CFR 3.104-4D. For some former employees, this prohibition may run for 2 years or life. U.S. Law 18 U.S.C. 207 prohibits former officers or employees of the executive branch from knowingly making a communication or appearance before the government on behalf of a person other than the United States about a matter in which the government has a direct and substantial interest involving a specific party or parties. If the former employee was involved personally and substantially in the matter, the prohibition is permanent. If one knew the matter to be pending under his official responsibility a year prior to leaving government employment, the prohibition is for 2 years after leaving. Criminal penalties include a fine or imprisonment. A special note for DoD clients. DFARS 252.203-7005, representation relating to compensation of former DoD officials. A DoD official who, within 2 years after leaving DoD service, expects to receive compensation from a DoD contractor shall, prior to accepting such compensation, request a written opinion from the appropriate DoD ethics counselor regarding the applicability of post-employment restrictions to activities that the official may undertake on behalf of a contractor. What is a protest? As a reminder, you care about all this because the last thing you or the acquisition team wants is a protest which will delay your mission work. The term protest means a written objection by an interested party to the award or proposed award of a government procurement contract. Protests can happen both in pre-award or post-award. Protest may result in delays to the project and/or divert team resources from other work. Common protest allegations. Pre-award protests typically allege flaws in the solicitation, such as ambiguity, unduly restricting competition, small business issues, for example, improper set-asides, scope, for example, requirement exceeds the scope of the vehicle. Post-award protests typically allege flaws in the evaluation of award, conflicts of interest, unequal treatment of the offerers, for example, improper discussions, technical evaluation, for example, unreasonable, failed to follow the solicitation, scope, for example, awardee proposed items outside the scope of its contract. To avoid a protest, you need to know who, when, how, and what can be discussed regarding procurement information. Know when to contact a CO when there may be an issue such as COI. Know how to evaluate and document according to the solicitation. Protect procurement information. Your goal is to protect procurement information, which includes physical security, equipment, and documentation. Best practices include securing meeting rooms, computers, telecom devices, etc. by locking up, turning off, and putting away. Controlling and safeguarding documents at all times to avoid unauthorized disclosures. Do not leave documents open or unattended for any reason. Checking for printouts left on printers. Reporting security lapses to your GSA point of contact immediately. Controlled communication. No matter your role, do not discuss this procurement outside project-related meetings or teleconferences, for example, in coffee shops, elevators, and other public places. For example, if you receive a phone call while in public, wait until you get to a private location to speak. As a general rule of thumb, err on the side of caution. But here are some best practices. Discuss the procurement only with people who have a need to know, with individuals participating directly in the procurement and source selection process, as authorized by the contracting officer. Establish boundaries and need to know upfront and consistently. Your chain of command does not automatically have a need to know and is subject to the prohibition on obtaining procurement information. Remember, using means of communication that leave a record, for example, email or voicemail, may become discoverable documents, including attachments and metadata. Do not forward email or voicemail messages related to this procurement to people outside this procurement. This may destroy attorney-client privilege. Immediately report security lapses to your GSA point of contact. Documentation. Before award, your documents will be read by members of the acquisition team to include the Integrated Project Team or IPT, members of the TEB, Sector Director, Acquisition Director, and Legal Counsel, individuals familiar with the project and technical terms, stakeholders interested in having the award sustained. After award, your documents may be read by United States Government Accountability Office or GAO, United States Court of Federal Claims or COFC judge, Protesters Counsel, Department of Justice or DOJ legal counsel, and others, individuals not necessarily familiar with the subject matter, industry, technical language, or assumptions, stakeholders interested in having the award set aside. As a reminder, documents may also be read in non-protest contexts, for example, audit, congressional inquiry, DOJ prosecution of awardee, etc. Hence, document your decision-making fully but concisely by describing your reasoning, describing all assumptions unlikely to be known to an outside reader, defining all terms, providing citations for all external sources. Treat every piece of documentation as potentially discoverable by minimizing unnecessary documentation, dating all documents and numbering all pages. Avoid recirculating drafts by email, opting for the telephone instead of email where appropriate. Use a neutral tone. Avoid anything that may be interpreted as bias. In summary, a simple rule to avoid protest is to do what you say you will do in the solicitation and abide by established laws. Keep your GSA POC informed. Always keep your GSA POC and CO informed by reporting conflicts of interest, actual or potential, as early as possible. Lapses of physical security of premises, equipment, or documentation, actual or potential. Unauthorized disclosure of procurement-sensitive information, actual or potential. In the end, we all have a role in protecting the integrity of the procurement process. If there are specific questions you have, please contact your FedSimp CO.